Could all the panelists please switch on their mics and their cameras?
Good afternoon, ma'am.
Hi.
Hi.
Tamanna ma'am, could you please switch on your mic and your camera?
Am I visible?
Yes, ma'am. Greetings of the day. I am Nandini Tyagi, second year student at MNLU and on behalf of the Center for Research in International and Comparative Laws, MNLU Aurangabad, would like to extend a very warm welcome to everyone present here. We are delighted to have you with us on this splendid Saturday afternoon. The Center for Research in International and Comparative Laws is an initiative of Maharashtra National Law University, Aurangabad, devoted to the study of comparative and transnational laws and legal systems. It embraces analytical, theoretical, empirical, and socio-legal attempts surrounding the public and private law aspects of various legal systems and aims to encourage comparative legal studies in the transnational context of legal history, theory, philosophy, cultures, and traditions by tracking the developments in the field across the world. We have already released 4 issues of the Comparative Law e-newsletter covering the areas of public health framework, law and society, gender inclusive framework, environmental development and labor, and modern slavery framework on social security laws through a comparative perspective. We have previously hosted personalities like Dr. K.K. Agarwal, Dr. Maxwell Stearns, Dr. Selina Jolly, and several others. The ongoing case of RIT Foundation versus the Union of India has sparked a debate around the perennial issue of marital rape once again. And to say that the discourse surrounding the same is rather diverse would be something of an understatement. From lawyers to academics, everyone seems to have their own opinion on the issue, which, while encouraged, if not coupled with facts and a deep understanding of the nuances as well as the legal and societal dimensions of the issue, can lead to no productive outcome. On that note, to enlighten us about the same, we have today with us a brilliant panel consisting of Dr. Sarasu Esther Thomas, Dr. Tamanna Khosla, and IPS Isha Singh. Professor Thomas is an alumnus of NLSIU Bangalore and its former registrar. Over a span of 25 years, she has built up the Human Rights Lawyering Project and the Center for Women and the Law. She holds a master's in commercial law, but her areas of teaching and research are human rights, gender, and family law. She has been awarded several fellowships, including Linnaeus Palm, British Council, and the Wiscombe Fellowship, and has published widely on human rights, gender, and family law. Dr. Tamanna Khosla is a teacher of multiculturalism and feminism. Having completed her PhD from Jawaharlal Nehru University, she was Assistant Professor, Department of Political Science in Delhi College of Arts and Commerce. She has also worked as research associate in research institutes such as JNU, Wiscombe, and CSR, and has contributed subject-specific articles to several newspapers and journals. She is currently serving as director at Prajna Initiative in the United States. A former student of the Mayo College Ajmer and the Cathedral John Connon School, IPS Isha Singh graduated from NLSIU Bangalore in 2018 and has worked as a lawyer focusing on public interest litigation chiefly. The most notable case she won sought relief for the wives of manual scavengers who had passed away cleaning a septic tank. She fulfilled her childhood dream and qualified for the Union Public Service Commission examination with an All India rank of 191 in 2020. She is currently an IPS probationer. It is with tremendous gratitude and honor that we welcome this exceptional panel, and we hope that the audience finds the upcoming discussion just as fruitful and enriching as we endeavor to make it. I now invite Ms. Aishwarya Pandey, final year student at MNLUA, to have the floor. Thank you.
Thank you so much, Nandini. A very warm welcome to all the panelists and the audiences. I'm Aishwarya Pandey, and I will be the moderator for today's session. My heartfelt gratitude to the panelists to have taken out their precious time to join us today in this panel discussion on this very sensitive topic of marital rape, which has stormed debates across the nation. Being a member of legal fraternity, it is our foremost obligation to initiate discussions, have opinions, and welcome a variety of different perspectives on sensitive issues which put in the interest of the entire society at stake. And what could be better than having a special panel with us, which includes members from academics to administration and legal practice to social rights activism? With a view of serving justice to this pious obligation, I look forward to an insightful panel discussion. Now, before we start with the session, I would like to thank the attendees for sending across your questions for the panel. We have filtered them out to avoid any repetition. However, if you feel you have something new that has not been taken up by us, you may please drop it in the question answer box and we'll be addressing it at the end of the session. And also, if you wish to address the question to a specific panelist, you may mention that as well. So let's get started with the discussion. Recently, we are seeing a curious Twitter hashtag called marriage strikes or hashtag anti-marriage in response to a lawsuit seeking the removal of marital rape exception from Indian criminal laws. As we have attendees today both from the fraternity as well as from the non-legal background, I take a moment to briefly acquaint them with the current position of rape laws in the country and what these men mochas and strikes are all about. In India, Section 375 of the Indian Penal Code defines rape as sexual penetration, insertion, manipulation by a man against the will or without the consent of a woman, except for the sexual intercourse. I repeat, and I demand your attention, except for the sexual intercourse by a man with his own wife who is not under the age of 15 years. It is this very exception which is in the controversies recently. Now I want you all to pay attention to the gravity of this exception. It means that if you are a married man and your wife is above the age of 15, you will not be charged for rape or non consensual sexual intercourse whatsoever. Such a huge immunity, right? If one is asked to state the key element of the section defining and criminalizing rape, it would clearly be the element of consent of the woman. Now we have to understand this clearly that when you create an exception out of a provision which has its sole foundation on the element of consent, then you're not just simply creating an exceptional circumstance, but also disregarding the woman's right to consent. And this is exactly what the issue is all about. People across the nation have taken a very dim view of this exception. And I would like to begin with having the view of our learned panelists on this issue that it being the 21st century, why are we even having provisions like these, which, according to a lot of us, said to have been emanating from patriarchy, an evil that is deeply entrenched in the Indian society? Would it be wrong to say that for a lot of men in the country, marriage does act as a license to rape their wives? Because clearly, the gravity of the situation is reflecting from the fact that certain class of men are also afraid of criminalization of marital rape. Let's begin with Sarasu Thomas, ma'am. I request you to please give us a general overview on this. Over to you, ma'am.
Thank you so much, Aishwarya. And if I understand your question correctly, it is on, you know, why Indian society is, why there is, one group of people who feel that there should be, it should be criminalized, and another group of people who feel that it should not be. Okay, have I understood your question correctly?
Exactly, ma'am. Yes, ma'am. You may please go ahead.
Okay, so since we have lawyers, practitioners, the police in this forum, I thought I would just give a little bit of a background. Now, marital rape is nothing new to Indian society. And I understand most of the participants are law students from different years. And when you look at, the different laws that you have studied through your course, you will see one of the first few laws is, contract law, where a wife can, bind her husband for necessities. And, tort law, where we've seen that in early tort law, a wife could not claim tortious action against her husband because they were seen as one, they were seen as unity. And this extended to other laws as well, that, husband and wife being seen as one entity meant that a lot of different actions that the wife could have against the husband did not happen. Many of you also know that, and this is something we're all very fond of saying, that in the UK, the wife was no better than a chattel or property, where when she got married, the control of her property moved on to her husband. Now, in a patriarchal society like the United Kingdom was then, or England was then, since this is English law, this is not very unusual. But we also know that developments in English law and the commissions which were set up, or the bodies that were set up which tried to look at these issues on in the UK. When you look at it, you see, for instance, a former Chief Justice of the King's Bench in England, Sir Matthew Hale, looked into the matter, and he came to the conclusion that, when the husband and wife are now married, the husband of a woman cannot himself be guilty of an actual rape upon his wife on account of the matrimonial consent which he has given and which he cannot retract. So the basis of allowing for, or feeling that marital rape was okay, was this implied consent in a contract of marriage. Now, this is something that has come into many different laws, like the Indian Penal Code. Most of you are familiar with the Joseph Shine case, which did away with the criminalization of adultery, saying that, adultery is a matrimonial wrong. Why should it be, a crime? And recognizing the fact that a wife is no longer the husband's property, that you're saying, why have you trespassed on the property, and therefore I have a criminal action against the other man. So slowly we're seeing a change. But when we look at the IPC, we see that this philosophy that was there in England at that time also crept into the IPC in the way that it viewed the wife. So this is there was there with regard to adultery, and it continues to be there as far as rape is concerned. But when we look at India, we see that this is something that was, so comfortable to the Indian society. And to understand this, you have to look at another law, that is family law. And one of the first things that we learn when we study marriage and family law is Hindu law. And when we're looking at the types of marriage, we see that, there are so many different types of marriage, including marriage by capture, including marriage by rape. And, so the very fact that consent of a woman was necessary for a marriage was not considered. And therefore, consent for a wife for sexual activity with her husband was also not considered. So the climate has always been patriarchal in most Indian communities, and so it was very natural in that sense for for it to be stated that, well, a husband cannot rape the wife. The recent controversy, if you want to call it that, is, and it's not recent. I mean, feminists have for a long time been saying that the exception of marriage should be done away with. But the controversy, if you want to call it that, has come really with regard to child marriage. And if you look at India today and you look at the kinds of marital rape which are actually penalized, they are cases where children have been raped. So this may be under POXO, there might be cases filed under the child marriage law, PCMA. There may be cases filed on rape, on statutory rape, but usually it is under POXO. Now, we also see that a lot of these cases are this very vulnerable age group from 16 to 18, where, girls are running away and choosing to go away with someone else and getting married. So this girl child is exercising agency. And this is also something that feminists have critiqued about the child marriage law, that, presuming that a child will not have sexual activity till the age of 18, or not allowing children to make their own choices, means that it gives adults a lot of control over such laws. And if you look at the cases where marital rape is actually being penalized in terms of children, who file these cases? They're not children. They are these romantic cases where the parents are filing the case in order to split the child, where the child has exercised her opinion and decided to go away with someone else. And the parents are saying, no, who are you? Whether you're a child or an adult woman, who are you to make this decision on for marriage by yourself? And this is the very unusual thing. For those of you who would like to read more on this, our Center for Child in the Law has come out with a series of analysis of cases on POCSO. And there is some very interesting writing on this romantic marriage as well. So even where marital rape is being penalized today, we see that it is not being done at the behest of the child. It is being done at the behest of the parents who want to control child sexuality. Thank you, Aishwarya, for your question.
Yeah, thank you so much for your valuable insights, ma'am. That was absolutely convincing. In fact, no institution can survive if it is based on the evident subordination of one party. Thank you so much for your views. Let's invite our other two panelists to present their views on this, starting with Isha, ma'am. You may please give us your legal insights on this, ma'am.
Um, Good afternoon. The first thing I want to say is that Sarasu ma'am literally taught me all of this. So the fact that I have to speak after her is so humbling, and I feel like whatever I say cannot match up. And of course, I think ma'am is one of the first professors in my life who instilled feminist consciousness in me, which I carry till date. But ma'am, and you are awesome, still are as always. And coming to the question at hand, I actually agree with ma'am entirely. I think she very nicely laid out how, the reasoning given by Sir Matthew Hale, how today marital rape exception is underlies the notion of property. So when we talk about deeming this provision as unconstitutional, there are two things that the court really needs to address with regard to especially the Article 21 and 19(1) of women, and that is their right to consent. Because if you are property, you can't consent. But if you're not property, then you can consent. So the law needs to decide, what are we as women? Are we property or are we human beings? The second thing is that historically, and I'm sure ma'am can throw a lot more light on this, is that rape statutes, while they have been enacted acknowledging the harm that is caused to the survivor, it also has historically been associated with chastity, right? Which is why a married woman cannot be raped, because once you're married, you're chaste. So this is another notion which continues in our laws today, especially this exception, which this of consent and chastity, both of which need to be addressed. Now, how do we do this? Like ma'am was talking about misuse of the exception. The Hindu actually conducted a survey in 2014 of the trials that were taking place in Delhi courts, and these are after convictions and acquittals. They found that 40% of rape cases were actually consensual and had been filed by parents, as ma'am said, and not the parties. And 25% were filed on the grounds that there was a breach of marriage. So, in the legal practice, I was formerly a lawyer and now a cop. So I find myself in this really interesting position. So it's known as a technical rape. So a lot of technical rapes are also filed, and that's something that is not being addressed. So sure, I definitely agree that this section needs to be looked at again, because it undermines the autonomy of women. But I would like to address the second part of your question about marital strike. Now, of course, like Kavita Krishnan ma'am famously tweeted, we're probably lucky if all these men go on strike. So that's one way to look at it. But the fact of the matter is, even today as we discuss this, do we really have representation from that side of society, right? We need to also hear their views on this. And now I speak as a law enforcer. So I feel that when we come to misuse of laws, even as a lawyer, I have seen it happen. I practiced in the Bombay High Court. I practiced even in the Delhi courts. And I saw that 498A, 304B, dowry debts, they are misused. They are misused. A marriage goes wrong, and you will see people coming and saying, that is the reason, even though the facts on record will not tell you the same thing. Now you may argue that the punishment matters, like let it go to a court of law. But the fact of the matter is that the Indian criminal justice system, as it stands today, the procedures are punitive. So if you get stuck in any of these laws, the police can arrest you if they just give good enough reasons. You go inside, getting bail is a hassle, tariq pe tariq happens. So in a sense, you get punished even before you are convicted. Now, that's not the problem of the IPC. That's a procedural problem. But the fact remains, it's a very real problem, and it undermines the entire notion of being innocent until proven guilty. So when men talk about the fear of misuse that's going on, I think it is a very valid concern that needs to be addressed. And we can only do that by making it easier to file FIRs in false cases. So, for instance, in 2018, there was a case of Anisha Batra, an air hostess who died in Delhi, and there was a huge media uproar. And the air hostess's husband and his two aged parents who didn't even live with them were arrested and sent to Tihar jail. Now, the two parents were senior citizens, cancer survivors, extremely reputed people who never in their life would have demanded dowry because there was no evidence to prove it. Years later, they got acquitted. But the fact remains, what happened? They were wrong, right? How do they address it? So they came to us and we said, you go for a false complaint. Say that they filed a false complaint. But if you look at the Indian Penal Code, under section 182 and 211, in order to file a false complaint, you actually have to approach the same court which acquitted you. And only with the permission of the court can you even go on to file a false complaint. So I think this is a huge deterrence because then, let's say, like you get acquitted or discharged, then that goes into appeal. Then the lower court who discharged you does not want to accept your application because it's pending an appeal in a higher court. So all of this somewhere allows, our system allows for misuse of laws to take place. And it's important to plug this gap. So while we also cut down on, we render the marital exception unconstitutional, I think at the same time we have to address this major legal gap that exists in our systems so that when a person is wronged, they should have a remedy to assert their innocence. Thank you.
Thank you so much, ma'am, for your insights. You made a very strong point on the misuse of laws, and we would be coming to that in the later part of the discussion. Now, let's see what Tamanna ma'am has to say on this. Tamanna ma'am, over to you.
Thank you so much, Vida. Yeah. So, as a person, as a political scientist, I would like to look at the whole issue from a feminist lens. So, several feminists, for example, have pointed out sex as a tool of men's oppression of women, and this has largely been current legal scenario in India through Justice Verma's committee report, which spoke against this culture which exists in India, that women are being treated as sexual tools. One of the famous feminists who spoke about this was Andrea Dworkin in Intercourse. In 87, Andrea Dworkin published Intercourse, in which she extended her analysis from pornography to sexual intercourse itself and argued that the sort of sexual subordination depicted in pornography was central to men's and women's experience of heterosexual sex in a male supremacist society. In the book Intercourse, she argues that all heterosexual sex in our patriarchal society is coercive and degrading to women. And sexual penetration may, by its very nature, doom women to inferiority and submission and may be immune to reform. Citing from both pornography and literature, including Madame Bovary and Dracula, Dworkin argued that depiction of intercourse. Just a minute. Yeah, so now so this is what they were trying to say, is that uh, women face oppression in the way that which is difficult to cite. So Dworkin argued the depiction of intercourse in mainstream art and culture consistently emphasized heterosexual intercourse as the only kind of real sex, portrayed intercourse in violent or invasive terms. She argued that this kind of depiction enforced a male-centric and coercive view of sexuality, and that when cultural attributes combined with material conditions of women's lives, it's a very difficult situation for women to handle. Such descriptions are often cited by Dworkin's critics, interpreting the book as claiming all heterosexual sex as rape, but that's not really true. You can have a better relationship with your partner, and like you have better things in life, rather than you can have a couple. Dworkin had a couple. She was in a relationship, but ultimately she died of drug rape. And so then there are several other feminists like Catherine McKinnon, who spoke about who led the whole movement against pornography. And in Canada, both of Dworkin and McKinnon started this movement against pornography, that it spills over into heterosexual sex, and it results in problems for women. And according to Dworkin, marriage as an institution developed from rape as a practice. Rape, originally defined as abduction, becomes marriage by capture. Marriage meant the taking of vows to extend in time, to be not only use of but possession of or ownership of. So women are basically, owned. They are not somebody who is like independent of themselves. They don't have their sexual wants. It's just the want of the man who can discuss these things. So, and be assertive in a heterosexual relationship. So that was a problem with the LGBTQ community also. Like that's a whole literature which can be used for LGBTQ also. So now women uh, just a minute. So marital rape happens due to several issues such as exploitation, marginalization, cultural hegemony. Exploitation is when women feel exploited in current liberal assimilatory political setup. Exploitation as a concept has been used by several feminists, and so many have used this particular concept. And firstly, Young uses Marxist feminist Christine Delphi to explain why women are treated as sex objects. So she makes it clear that exploitation consists not in the sort of work that women do at home, but in the fact that tasks are performed for those on whom they are dependent. Young further elaborates her theory by looking at, it's drudgery. Household work is drudgery, plus being sex tools to their men, like providing them sexual labor, is another problem which many feminists feel. And marginalization means the concept that there's a growing underclass of people permanently confined to the lives of social marginals. So they are like social marginals who are treated in a certain way, that their whole personality is dubbed. So yeah. And many single mothers and their children, pregnant women, American Indians, Dalit women, especially those on reservations, suffer unduly. So it's not just about America, it's about India too. It's only very few countries which have passed marital rape laws. And in US some states have, in Canada some states have, Albania has, and many other states of Europe do have, but many of the others do not. So yeah, so India needs to have for sure a marital uh, rape law, which can which can help women to surpass more, as much as possible. And like I'll just like to talk to you about the French feminists, who are very much interested in this particular issue. And they're French linguistic feminist Helena Sixou Luke Rigere and Julia Kristeva, they talk about the fact that women are in a phallogocentric world. Phallogocentric means phallus related world, where importance is given to the phallus and not the vagina. So women should be satisfied with their own way of living, because they're lesbian feminists. They talk about women and their touch of themselves. So yeah, thank you so much.
Thank you so much, ma'am. That was absolutely convincing. This also brings me to what recently senior advocate Rebecca John, ma'am, has said while assisting the courts on this issue of marital rape, that this exception attached to Section 375 is not a mere exception but an exemption against the criminal liability. It is in the nature of immunity, which means that it is acting as a shield for the men from any charges that they might face from their wives. Now, coming to the next question, and I would be addressing this to Thomas, ma'am, that the center and courts have time and again said that criminalizing rape involves family issues and cannot be seen from a microscopic angle. But some are also of the opinion, ma'am, that when you are refusing to look into the matter and generalizing it as a mere family issue or personal affair of a husband and a wife, you're also neglecting the agency of sexual autonomy which a married woman holds onto her body. We have to understand that these are not trivial cases or private affairs. Rape by itself and in its very nature is a very serious offense. So, what then is the difference in the trauma faced by a 14-year-old and a 25-year-old woman in the case of non consensual intercourse with her husband? How do you see this exception benefiting only a particular age group and excluding others from its ambit? Over to you, ma'am.
Thank you, Aishwarya. Actually, there are, probably two questions to the two parts to your question, so to speak. And the first one is, of course, on marital rape affecting the family, which is, such a common argument that we come across. And the other is treating, an adult woman and a child separately. So maybe we can, my suggestion is we go around the table with the first issue first and then take the second, because they are very different from each other. The first one is on whether it's a family matter. And, to put it very simplistically, I know many of you are still very young in in your legal studies. So generally when we talk about, uh, issues dealing with people in families, whether they're women or children, we tend to talk about, what is called the public and private divide. That things which are in the public sphere, like, your employment. Now, nobody will say that, women and men should get different salaries for the same job. I mean, nobody will tell me that male professors at the same level as me should be paid more. So in the public sphere, or, no one says that a stranger should have a right to rape a woman. So in the public sphere, we see that a lot of rights are given to women and to children. So when we look at child sexual abuse, for instance, you'll see if it happens in a school or a public space, all the parents will go and gear out the school and beat up the principal or beat up the teacher who's been suspected. But when it comes to the private sphere, it's as if law stops at the door of the house. And we see the same argument being used whether when we are talking about beating of children as punishment, when you're talking about things like restitution of conjugal rights, when we're talking about domestic violence, or we are talking about marital rape. So suddenly the family becomes sacrosanct, as though rights do not come into the private sphere. And now this is something that has been critiqued not just by women's rights activists, it's been critiqued by child rights activists, by disability rights activists, to say that, all the rights that are available under the Constitution, the guarantee of equality is available everywhere, not just outside the home, but also within the home. So if a woman faces violence or a child faces violence within the home, it is as actionable, as much as a crime, as the violence that she faces outside the home. So this unnatural distinction of saying whatever happens in a family, even if it's a violation of a right, is all right, is no longer acceptable. Not at all. So we are still understanding different intersectionalities like women, like children, like disabilities. But clearly, we are now at this junction where we understand that violation of rights, whether it is outside the family or inside the family, is no longer possible. Now, when we look at things like, abuse of the law, do you have a separate question on that? Then I can hold my statements till then.
Yes, ma'am, we do have.
Okay,
We
then
do.
we'll wait till then. So that's what my feeling is, that this whole public-private distinction is only raised when you're looking at vulnerable people within the family. And this is a distinction which the law has consistently, and our constitution has consistently tried to remove. And I think it should stay removed. So if sexual intercourse is supposed to be a pleasurable activity for both individuals with consent outside the family and outside the home, it should also be a consensual, pleasurable activity within the home. Thank you.
Yeah, thank you so much, ma'am. Now, moving on to Isha, ma'am. Ma'am, if we look at the history of Provision 375, as you also stated, there the marital rape exception was given to us by our colonial masters based on a doctrine from 200 years ago, the doctrine of coverture, where a woman's legal rights and obligations were subsumed by those of her husband after the marriage. It meant that the woman could not perform activities like buying property, or entering into a contract against her husband's wishes. Instead, in return for protection and support, women owed their husbands a consortium of legal obligations, including the sexual intercourse. But the colonial masters themselves had judicially discarded this exception back in the year 1991. So, ma'am, similarly, does it also not become the duty of the courts to strike down a law which is structured in aiming at destroying the constitutional freedoms? What is it that is stopping the courts from criminalizing it? Ma'am, you may please present your views.
Thank you, Aishwarya, for that question. You're absolutely right on how late we are to the party. Canada struck it down in 1983, South Africa in 1993, Australia in 1976, and here we are sitting in 2022, still allowing marital rape as a legitimate defense. So, of course, I think that what has stopped us all these years ultimately is we've not been able to channelize our demands properly. As women, I personally feel we are not a very strong pressure group or a vote bank. And that allows a lot of our concerns to go unaddressed. It goes without saying, a lot of our legal system today, as it stands, is a colonial inheritance and is deeply rooted in patriarchy. And what has started now is an actual attempt to make reforms and change this. And what I find personally very interesting, there's this book called The People versus Democracy by this American professor called Yasha Monk. And he says that the parliament can be populist, but it is the court's job in a liberal democracy to protect the rights of the individuals or the minorities and the disadvantaged. So we actually are turning to the courts rather than our parliament. If you look at it, it's really interesting to make changes. And the thing is, like what Sarasu ma'am said about the private and public divide, that is something that even the courts are now coming forward to acknowledge how faulty it is. If I may quote Justice Chandrachud in the Joseph Shine case, which struck down the adultery law, he said that the delineation of private or public spheres has become irrelevant as far as the enforcement of constitutional rights is concerned. Therefore, even the intimate personal sphere of marital relations is not exempt from constitutional scrutiny. So you have the Supreme Court, a constitutional bench of the Supreme Court saying that. And I also want to quote Justice Lokur in the independent thought case, because he very aptly highlighted the problem with the marital rape exception, that, and like you said, exemption. A husband can be prosecuted for lesser sexual offenses under 354, 354B, 377, but not for rape. Indeed, slapping your wife or killing her in a bedroom is specifically criminalized, but not raping her. So, the Supreme Court has started acknowledging it. It would be nice if the Parliament did it too, because as it stands today, a major issue that the Delhi High Court faces is that while one side is arguing that there is uh, this is a pre-constitution legislation, and that is why there is no presumption of constitutionality, but it can also be argued that the parliament reenacted the rape laws in light of the GS Verma committee recommendations, and after that they retained this exception. So the court is hesitant because there may be a presumption of constitutionality and they don't want to enter that domain. One more thing I'd like to point out is that of course this is an issue, maybe you have a separate question on it regarding the differential treatment, because 376B says if you are separated, then the punishment is a lot lesser than if you're an unmarried woman, and if you're a married woman then there's no punishment. So obviously marriage is the reason, but the fact remains that rape laws have a 10-year imprisonment. So that is something that again would make it very stringent. And I think that's something that the court is actually concerned about right now.
Yeah, thank you so much for your wonderful insights, ma'am. And I also believe that in doing so, in criminalizing this exception, the court will not be adopting a paternalistic approach, of course, but will only be fulfilling its duty to give effect to the rights that have been already enshrined in our constitution. Thank you so much, ma'am. Now, I'd be moving to Tamanna Khosla, ma'am, and addressing the next question to you. Ma'am, the question is that the union government has said that marital rape cannot be made a criminal offense as it could become a phenomenon that may destabilize the institution of marriage and can be an easy tool for harassing the husbands. Ma'am, could you please throw some light on what do we mean by destabilizing the institution of marriage? Can sexual relationship with the spouse be considered as a legal or conjugal right, depriving women of all the rights over her bodily integrity the moment she steps into the marriage?
Not at all. I completely agree with the fact that, marriage is not something which is sacrosanct, and it's not something in the present century. We cannot say that these have come from scriptures, and it's a very legal document which we are supposed to sign, and it's a legal relationship. It's not sacrosanct, and till the time women's integrity of body is not respected, marriage can really go to dustbin. It's really, it's not something which is so sacrosanct that any woman's integrity of body is violated. So any violation of woman in in this particular respect should be regarded stringently by the Parliament of India. And it should, as Isha was also saying, that it should come from the Parliament. It's the people's house. It's the people's voice which should be heard. 50% of us are women, and we don't even have a voice in Parliament. 33. We should have 50% representation. We don't even have 33%. Till the time that doesn't happen, and these women are not run by the male politicians, till that time, women should have the right of representation of their voices. And women politicians should come together rather than as party tickets which are granted to them. The fact that they are Lok Sabha and Rajya Sabha members, they should take take this particular aspect into cognizance and raise voice against, because we have many fiery and fiesta filled politicians who can make a choice. Right now in UP elections, for example, most all the 3-4 political parties have their concern about women. So basically the fact is that maybe women are emerging as a group. So till the time the women do not emerge as a group, and you have men controlling their lives, women have to come forward. And for example, Mulayam Singh is saying that 33%, oh sorry, a scooty, so is BJP is doing, the Congress is also saying the same. and many other soaps are being given to these women. So I guess women are emerging as a group, and people, political parties are feeling that they cannot neglect women anymore. So yeah.
Can I just add one small point to that? I think what Tamanna ma'am said is very true. And everybody promises 33% reservation, but when push comes to shove, they tear the women's reservation bill in the parliament, and we women just sit here as spectators. And I think that's something that needs to change in the coming future.
Absolutely, ma'am. That's absolutely important that the stakeholders should definitely have a say in the laws that is made for them and be given the right of voicing out their opinions. All right, so we'll come to the next issue, and I would address this to Sarasu, ma'am, that women have been looped into this vicious cycle of shame and honor, as a consequence of which they have been attended with an inherent disability to report crimes of sexual offenses against them. A wife was deemed uh, to have consented at the time of marriage to have intercourse with her husband at his whim. A woman is seen to have been risking her reputation and honor by reporting a crime of sexual assault against herself. While intercourse is an important part of marriage, ma'am, the assumption that there is consent in perpetuity and therefore the woman can be forced to have intercourse makes this assumption problematic for those women who are in an abusive marriage where rape is a tool of torture used by the husbands. Ma'am, there's also an assumption that when a couple gets married, the woman gives consent in perpetuity to her husband, and the woman cannot simply retract her consent after she has given it to her husband at the time of marriage. So, ma'am, may I please ask you that what are the reasons which you would like to enlist for not reporting these cases, and the reason why the gravity is still not exposed?
It's a very good question that why don't women report cases? But I think it's also a larger issue when you're looking at the kind of the various kinds of violence that women face. And I think just to repeat what Isha said, that domestic violence is a crime, so why not marital rape? So even domestic violence, I mean, most studies show that about 40 to 60 women in families, 40 to 60% of women might face domestic violence. But you don't find so many cases of 498A being filed. So when people say that 498A is being misused, I keep saying it's not even being used. Most women do not file cases when you're looking at issues of domestic violence. And so even the provisions that are already available, you don't have many women complaining. The reason that you needed to, that you had, the POSH Act, which protects women, which tries to take action where women face sexual harassment at the workplace, is to provide a non-criminal remedy so that a woman can go to the workplace safely. The reason you have a domestic violence act is that women don't want to file criminal cases. They just want the violence to stop. So, so especially when you're looking at the family and women are in relationships of, love or, you've said honor, whatever they feel is, an essential role for them, they try to do. So when you look at women who are actually filing these cases, they're filing it because they have no other option, or they, that they feel there are some women who exercise agency and they feel that this is something that they really want to do. So the non-filing of cases is not limited to sexual violence, where you can't file a case. Non-filing of cases extends to so many other factors where where violence in a family is considered to be normal or natural, and talking about it outside becomes shameful. That's also something that you have, I think whoever's asked the question has put it very clearly. And I always tell people that, women who file these cases are looked at, family, those who are breaking the family. And I keep saying the family did not break, or the marriage did not break when the woman filed the complaint. The marriage broke when she faced the violence. And we need to see the difference between these two. That the the marriage has broken when the violence has been faced. The other thing that you talked about was, where she has consented to the marriage. It's assumed that she's consented to sexual intercourse. Now, consent and marriage, as I pointed out at the beginning, and that is something that I might like to disagree for a bit. Is we are very fond of blaming the present law of marital rape on, as we say, our colonial masters. But the fact is, it gelled very well in the way that we saw marriage in India, where marriage in India was not really done with consent of parties. The only form of marriage in Hindu law which was with consent by adult parties is the Gandharva form of marriage, which is not even a very approved form of marriage. All other forms of marriage, it was the community or the parents or the man himself, deciding, I want to marry this woman, which forced her into marriage. So consent of a woman to a marriage is very tenuous in the Indian context of arranged marriages and of child marriages. So when a woman consents, there is really, there's no real consent on her part. And we've seen that in what is commonly called the Hadia case, where a woman decided to, on her own, decide to marry someone else, on her own, decide to change her faith. The entire system came down so heavily upon her to say that you don't have the right to do that, even though she was an adult woman. So to say that she's consented to sexual abuse, sexual activity itself is, I think, carrying things too far. And we know that marriages are a mix of different things. And of course, there are other provisions which a man can use if there is no sexual activity, or a woman can use if there's no sexual activity, including divorce on the grounds of impotence, or divorce on the grounds of not consummating the marriage. But considering it to be a right is something that I find it very, very difficult, because in a marriage should be with consent, and sexual activity in a marriage should be also with consent. So there are a lot of times that consent is not considered to be necessary, and that is something that we as a society need to challenge very, very clearly, that society should not be controlling this entire issue of a woman's consent, whether it is to a marriage or what happens to her in a marriage as well. Thank you.
That was absolutely insightful, ma'am. And I would also like to highlight the statement you made that a marriage breaks at the time and the moment that any action is taken against the consent. Now, I also request the audiences to please feel free to use the chat box and express your opinions on this issue. We would love to read what you have to say. Now, coming to the issue of misusing this law, and I would like to address this question to Isha, ma'am. While I was going through one of your interviews, I came across a statement that you made that you cannot just simply back out from legislating a law which criminalizes a particular offense with a fear that it might be misused. And if that is so, then there is a possibility of every other law being misused. And we also have a specific question coming from the audiences to this issue, that in a time where maximum number of domestic violence cases filed in the courts are frivolous, what is the guarantee that criminalizing marital rape will not further add to the vulnerability of Indian husbands? And don't you think that the current practice of burden of proving the allegation should also be changed and tilted towards the women who allege the offense? Over to you, ma'am.
Okay, that's a lot of questions. I'll address them in a mixed fashion. The first thing I wanted to talk about what you said, that what I said in my interview, and that actually ties into what Sarasu ma'am said about the Domestic Violence Act or the 498A, because interestingly, in my UPSC interview, I was asked the exact same question, that 498A is misused, it needs to be thrown away. Now, as a practicing lawyer, I have seen cases of misuse, and I stand by that. People do misuse the law. But I told her the exact same thing that ma'am said. I said, there is a vast underclass in this country that doesn't even know the act exists. In Mumbai slums, you walk the streets and women are beaten every night, but you will never see them walk up to a police station the next day. And from our training, right now I'm undergoing training at the Lal Bahadur Shastri National Academy of Administration in Missouri, and they took us for a village visit. So for 10 days from I found myself in easternmost Bihar in Araria district in the small village of Bhangahi. And there, what ma'am said about consent is very valid. I mean, girls don't get married at 18. They get married at 14, 15. And even if they want to study more, there are no avenues, there are no schools, colleges, and community structures are so patriarchal that consent is entirely vitiated. So this is a huge reality that India faces. I like to think of India like a lot of people do. India, that is Bharat. There are two Indias. One India is us, and there's another India that doesn't even know the C of constitution. So these laws are actually protected to empower them as well. So when I spoke about, you can't just use misuse as a reason to not enact a law, I think I still stand by that entirely, because there's so much social transformation that needs to be brought about. And let's say we enact the Child Marriage Act, even if people are getting married at 15 now, but because of the act it's 15. Earlier it was 12 or 11. So definitely laws make a huge change. But having seen misuse of laws, this particularly comes by people who have access to legal resources, who perhaps want to settle vested interests through the use of these laws. And I truly believe in individual rights. So if I champion the cause of a woman's right to her bodily autonomy and right to consent and make choices, I also believe that an individual's right to remain innocent until proven guilty should be equally protected. And that's what's really interesting about our legal system, because we have a duty to balance two things: punish the guilty and protect the innocent. So one cannot come at the cost of another. And which is why the US case People versus Liberta, it's quite iconic. In 1984, New York Court of Appeals, that was a really good case, because while they held that marital rape is not an exception, they they also said it can't be mitigated. You can't give a lesser sentence just because somebody's married. Rape is rape irrespective of the nature of relationship involved. So that was a really landmark judgment. But they also brought in gender neutrality in rape. They said just because women don't commit rape as much as men do in terms of statistics, it doesn't mean that it shouldn't be an offense. So I think the future, if we as a society want to progress, I already spoke about misuse, so I won't go into that again. But the point remains, we need to make it a lot easier to challenge the false cases that may be filed against us. That is a loophole we need to plug. But the second thing we need to do is, if we truly want to be a just society, we need to bring in gender neutrality as well, because men who are assaulted, who are raped, they must also have a remedy in law. And I feel 21st century India is an inclusive India, and it has place for everybody. Thank you.
So, ma'am, in furtherance to that, also, don't you think the legislation should bring forth a clause which provides for a deterrent action against the frivolous complaints that can be related to marital rape, ma'am?
That's my personal
Are you
opinion.
able to
And
hear us, ma'am?
uh, wait, are you asking me? You're asking me, right?
Yes, ma'am. Yes, ma'am. May I
Yeah,
please
my
repeat the
personal
question?
opinion. Yeah, no. I got the question.
Okay.
I
Okay, ma'am.
personally think that this whole narrative that personal laws are misused is blown out of proportion, because all laws are misused, perhaps with the exception of murder. And even there is misuse. Like I said, I was in Bihar. The father will commit a murder, but the 12-year-old child is in the juvenile home. The 12-year-old child was in school, had nothing to do with it. Isn't that a misuse of law as well? So laws are misused on the house. I don't think that you take a specific crime and say, oh, this is likely to be misused a lot more, so let's put in a specific safeguard. I think that actually dilutes the whole uh, the whole idea of allowing women the right to choose, because somewhere it's creating a preconceived notion that women are likely to misuse that right. And I think that's insulting, in fact. But what I would say is, in general, like I said, the CRPC and the IPC make it so tough. Those things must be made easy, that if you were not able to prove in a court of law, if even during investigation you can't put on record anything to show rape, violence, or demands of dowry, then I must have an immediate solution to that. I must be able to file a counter FIR there and then, saying that this person has not been able to produce evidence and they've maligned my reputation, or I've gone to jail, whatever it is. The fact that because this doesn't exist, because so many people go scot free when they misuse the law, even if it's a minority, it creates such vast discontent. And I feel in the long term, it is actually a setback to women's rights.
Thank you so much, ma'am. I do agree that the procedure of immediate redressal must be there. Your answer was truly insightful. Now, moving to Tamanna, ma'am. On the counterpart, we also have a special view that rarely will a girl or woman in India make false allegations of sexual assault on account of any such factor, because she, in the traditional bound non permissive society of India, would be extremely reluctant even to admit that any incident has ever occurred to her. She would be conscious of the danger of ostracization by the society. She would have to face the risk of losing the love and respect of her own husband, of her matrimonial home and happiness being shattered. Because you see, no matter whatever party wins, the husband or the wife, it is them and solely them who have to get back to the home together and resume their matrimonial obligation in case they are not separating, right? So, ma'am, what are your views upon this?
I feel that for sure that, like, women face the brunt the most, and like, be it at workplace or be it in families, these issues are raised in a very pertinent fashion, and these things have to be taken care of. Women, despite the fact that in universities everywhere, we have sexual harassment committees, but I mean, I was in JNU, there we had GS cash, but these things do not get addressed in a fashion that, because the girl is going to move back, and there are threats of all kinds, because men are generally in the position of power, and the minute you are in the position of power, you can suppress the, why, be it a woman or be it a man. It's not just about being a man. In any kind of harassment, not just sexual harassment, be it of any kinds, you have you have people who are senior to you and who will try to muzzle your voice. So I guess women, uh, till the time women do not get representation in the parliament, and we do not acknowledge a sexually differentiated citizenship, that we have a citizenship which is differentiated, and that differences between men and women need to be acknowledged. And the fact that the problem is that some women seem to enjoy a certain kind of attention, but they are not asking for sexual harassment. They might just be wanting to be friendly with you or something, but if it's just taken to the extent that they are wanting to be raped or harassed or something, that's extremely patriarchal, and it should be avoided in all the possible ways. And so like uh, so this is the whole thing. And marital rape being the issue, this issue has to be addressed from the basic basic levels. And till the time this is not addressed, a society which is democratic, where we are talking about deliberative democracy in the present times, and where women are able to talk, women can be CEOs, and they can be the directors of companies, etc. That would not happen if she faces failure in home itself, because she is treated as she does not have the right to address her own problems. So how will she lead the world? So till the time we do not have that political representation and women in the true sense in the parliament addressing women's issues, uh, these kind of problems are, even the judiciary would not be able to do much, because marriage is something which is considered to be sacrosanct in Hinduism, for example. It's not a contract, unlike other cultures. So, because it's a religious practice, and it can't be broken. It's a 7 साल का संबंध है आपका, 7 जन्मों का संबंध है आपका. So, those kind of things are there. So, till that time, even the judiciary will find it problematic to take certain steps. So, yeah.
Thank you so much, ma'am. Thank you. Thank you so much. I also agree to what you said, that we need to break this bridge, which is sexually differentiating the people in a nation of democracy. Now, moving to Thomas, ma'am. We have seen that even in serious offenses, which had led to the breakdown of marriage, like dowry, domestic violence, etc., the courts have always made an attempt to save the institution of marriage. So, can the courts not adopt the same view on cases of marital rape as well? As the offender is not an outsider but a woman's own husband, and they ultimately have to take the charge of their own marriage if they are not divorcing each other. Or should divorce be the only available option, as the marriage is already tainted with the allegations of marital rape? Can you please present your views on the same, ma'am?
Um, I would also like to add to what Dr. Tamana said a little earlier on, the marriage itself. And I think in our previous response, she had said about, that we see the marriage as essential and something that should carry on. And even now, she talked about marriage being a sacrament in many communities in India. But when we're looking at the judiciary and saving marriage, we also need to look at what exactly this institution of marriage is, and whether it needs to be saved. And as I said, the breaking of a marriage does not happen by the judiciary. The grant of a divorce is not what breaks a marriage, but that initial violence is what causes this, the initial matrimonial fault, marriage, whether it's a violence in any form, including marital rape, is what has actually caused the marriage to break down. Or it might be two people feeling that, well, we don't get along, we are not compatible, we got married, or our parents got us married, but this is just not working for us, so we'd like to go our own way, and they mutually agree to go their own way. And I think that when one of the people in that relationship, or in case of mutual consent, both of them make that determination, or if one the woman has faced violence and she says, I don't want to be in this violent relationship, I don't think it is right for anyone, particularly the judiciary, to say that it is, we want the marriage to continue and we don't care whether you face the violence or not. I mean, that sounds so wrong, right? So saving the marriage at the cost of the violence of a woman is something that is simply not acceptable, and that is something that is not to be done. And when we look at the people who might, they always say that, oh, but there are children in the marriage. Well, children will find, they're very resilient. I mean, they'll find that there are so many marriages now where parents live apart and where they co-parent, where they have joint custody, and children are brought up. It's not that the entire system is collapsing, because divorces have become more common. And we see that the Domestic Violence Act has also been used to give women protection, even when they don't want a divorce. So I think things are much more nuanced now, and we have to look at it in that way. So a divorce does not break families. It's families are broken either by behavior of one party which causes violence, or both of them deciding that we don't want to be together. And I think when we look at the constitution and we look at society, constitutional values in terms of giving rights to individuals are what we need to look at, and not social values, because constantly the constitution and culture will clash. You know, every time you're trying to give a constitutional right of protecting a woman, it may clash with some other cultural rights that society thinks it has. But we need to remember, and I think that was probably quite clear right from the NAS Foundation decision on 377, which many of you may be familiar with, that in India, the only culture that we have as a country is that of a constitutional culture, what we call constitutional morality. So this constitutional morality puts individual rights much ahead. And that is the thing it protects, not social values or culture or whatever else it is concerned. So I do not think it would be right for courts to say no as a citizen of our country, or we don't think you have the constitutional rights to get out of a situation of violence because we think the family should stay together. So I'm very clear where the right is situated. It is situated in our constitution, and everyone, including courts, have to uphold that constitution. Thank you.
Thank you so much, ma'am. I truly appreciate a very strong point that you've made when you say that constitutional values and social values are at bound at some point of time to be in conflict, and constitutional culture protects rights much ahead than any other culture would. Thank you, ma'am. Thank you so much. Now, coming to the issue of gender neutrality, and I would address this question to Isha, ma'am. If we talk about any law, we have to view it free from any prejudice and biasness. Heinous offenses like rape that can have a traumatic impact on the physical, emotional, and psychological state of the victim should ideally be gender neutral. So my question to you, ma'am, is that does gender play a role in the offenses like rape, specifically marital rape? As under provision 375, only a man has been made a perpetrator and only a woman a possible victim. What are your views on this, ma'am? A situation where victims can be men.
Uh, Absolutely, Aishwarya. I mean, it goes without saying that gender plays a massive role in these kinds of offenses. We outline the entire history of, consent and rape statutes, and we've seen they've always been geared towards objectifying the woman or protecting her chastity like she's, an object to be protected. So that's where all these offenses stem from. And radical feminists, and even in fact liberal ones, but particularly radical ones, will go on to say it is a tool to perpetuate patriarchy in society. Sexual violence is a tool for men to subjugate women, according to radical theorists. So this is something that it's a reality, I would say, and it's not something that we can ignore. But we have also reached, I believe, every society progresses uh, with centuries, and we are in at a space of consciousness where we recognize that while we always view these offenses in terms of heterosexual relations, man and women, sometimes these offenses are men or women men. This also happens even if it is a minority. And I think that, like ma'am said, and the courts are there to protect individual rights. The parliament is there to represent the majority, and that is where our liberal democracy strikes that fine balance. So till the time we can't show at this point where we stand today in 2022, perhaps 1950 was a very different time period for India, but as we stand today, this is something, again, the New York court said in People versus Liberta, that you need to show what is the objective of not criminalizing only a class of offenses. What is the objective today of criminalizing offenses only against women and not men? Of course, we can argue that women are more vulnerable. They are. We have enough statistics to show that. Like we said, women don't even come up and complain. They don't even know they have the right to complain. So all of that is true. But at the same time, do we have a solid enough reason to leave men who have been survivors of sexual assault out of the picture? And the government, at least from as I see it today, I don't think it does. Is there a government objective there to not allow wrongs against men to be addressed. So that's something I think we need to address, and it would be best if rather than the courts, the parliament addressed it, or perhaps the courts and parliament could go hand in hand and have this conversation, because it's something that's been long overdue.
Thank you so much, ma'am. You're absolutely right. And in continuation to this, we also have another question coming in from the audiences. But before that, I'll quickly make an announcement that as we are now moving to the end of the session, I would request the audiences to quickly post any new questions which haven't been addressed, which they might have in the chat box, and we'll have a quick question answer session after this. So coming back to you, ma'am. We have this very thoughtful question that could someone be charged with attempted rape in a relationship where there is a regular sexual intercourse? How would evidence of an attempt be considered?
So that's actually really interesting, because this is the primary argument against rape exception, that how do you prove it? And this is very laws, even when people are in a relationship, let's say 99 out of 100 days they have consensual sex, and the one they don't, how do you prove it was forced? And this becomes even more complicated when let's say it was 45 days you were consensual, 46th day you were not, and then rest of the days you were, but then on the 101st day you go to the police station and say I was raped. I mean, an offense is an offense, but as again the law enforcement or the prosecution, it becomes quite difficult to navigate this these kinds of claims. And here what becomes really important again is your evidence act. Cross examination is actually quite a powerful but understated tool, I would say, because only when you come to courts do you realize how important the statements and witness statements etc are. And of course, again in these offenses the number of witnesses become a lot lesser, but you could have, let's say, spoken about it to a friend, and that friend can come attest to that. You may have gone to a doctor right after that. So all of that, of course, because attempted rape might have marks of violence, of which you may have addressed, whatever. It's the circumstantial evidence that will eventually prevail in such kind of cases. And this is where I feel the role of the prosecution also becomes really important, because when you start practicing, you will notice that in most parts of our country we have a very lax prosecution. The prosecution doesn't do their job as well as they should, or maybe there are just extraneous factors involved. But for instance, conviction in rape cases, although we are talking about the marital rape exception, is only 29%. That is nothing. I mean, countries like Japan almost have 100% conviction rate for their cases, and India lags behind. So uh, the prosecution's role becomes really important. How the investigative agencies, how we as the police, go adduce all the evidence, how we come to the conclusion. I think here the state's role is very important in order
Absolutely,
to
ma'am.
prove or disprove the case.
Yes, ma'am. Absolutely, absolutely. Now, moving to Tamanna, ma'am. This question is addressed to you, ma'am. Is there a connection between marital rape and lack of sex education? And can the situation be improved if proper sex education is provided from a very young age? Over to you, ma'am.
Yeah, sure. I definitely feel so, Aishwarya. If sex education to men as well as women, uh, because I have realized that, even in schools, for example, girls are like least knowledgeable about the fact that they're entering into a sexual relationship with their friends, and like what it entails, and they should know everything about it. Uh, what problems can she face about this? You have written in all these places where there are amazing amount of teenage pregnancies, despite the fact that they give sex education. So sex education should be in such a way that it empowers women, empowers women, as in like they should know that to they have a way of their life is just moving ahead. They have to realize that they might not find the right partner at this age. They can just wait a bit, and like till the time they do not their education is not complete or something, they should, even if they enter into a sexual relationship, they should know protection, all the basic know-hows of having sex with some male or female, anybody, of their choice. And they should know what are the repercussions of it. And sex education is not just about teaching them about sex, but also many other things which are related to uh, sex as such as an act. So they should be given that, they should have that right to know that, this might lead to this, and these are the consequences, and this needs to be addressed in certain ways. And what are pregnancy related problems, and what she might face, and what kind of how should she avoid it, as in, like, if suppose she is pregnant, how should she deal with it. And like, the doctors should be more sensitive towards girls who get pregnant, for example, in that age, and not accuse them, or like, blame them, but be more responsible, as they're still children, they're just experimenting. So till the time they are not aware about these facts, sex education in all possible ways should be given. Thank
Yeah, thank you so much, ma'am. Coming to the last question of the session, and this is an open question to all the panelists. Starting from Sarsu, ma'am. While I was going through one of your beautiful analysis, which you have made in relation to the empowerment in the Christian Conference of Asia last year, you have made a statement that there is no question of women empowerment without reducing the power in other hands. We cannot expect the women to be resilient or fight back or reclaim the power solely by themselves. In today's time, ma'am, where we are talking so greatly about women empowerment, equality of opportunity to women, don't you think all of this reduces to nothing when you don't give her the right to have autonomy over her bodily integrity? Can you please help us understand the importance of sexual autonomy in the light of empowerment of women, ma'am?
I can't remember who made this very nice statement, but that's something that I agree with, which is, to women their rights and nothing more, nothing less. To women their rights and nothing less. To men their rights and nothing more. You know. So usually when we talk about rights, we see that there is always an uneven balance in the way that it works in society, as well as in the way that rights are reflected in the laws, as in the present context of discussion. So it is absolutely essential to recognize that women are rights bearing individuals, uh, and that they should have all kinds of rights. Now, this entire area of rights called, which are loosely called reproductive and sexual rights, is something which people are only starting to talk about now. And women's rights, where reproductive rights are concerned, whether it is when to marry, whether to marry at all, whom to marry, when to have sexual intercourse, or when to have children, the spacing of the children, how many children to have, whether the children should be male or female. All these decisions are, very intimate decisions which involve her body. And we find that a lot of these decisions are not taken by her. They're either taken, by the man she has married, or more commonly, possibly also taken into by, the senior members in the family that she is part of. And certainly, when we talk about sexuality, we do recognize that just as we are all autonomous beings, we also have uh, women should. The idea of women's sexuality is very much part of this entire gamut of reproductive and sexual rights, and that should be recognized. There are a number of activists, including child rights activists, women's rights activists, who say that the autonomy of children should also be recognized. So right now, children are treated as neutered, non-sexual uh, beings, who become sexually active suddenly when they reach adulthood. And the Convention on the Rights of the Child talks about what is called the, evolving capacity of a child. That you look at not all children, don't tar them all with the same brush. but you look at evolving capacity of a child. And this evolving capacity is what makes, to add to what Dr. Tamanna said, the sensitization of children, you know, or teaching them about sex or talking openly about sex right from the time that they are in school, instead of not letting people know anything about sex or contraception or anything, even much after they are married. People are unaware of these things. So I think that change must somehow come in order for us to have a happier kind of a society. And have I answered your question? Have I left something out?
No, you have.
The
You
second part
perfectly
of
have,
your
ma'am.
yeah. So I think that not recognizing people as autonomous individuals and lumping them as part of a family or lumping them as someone less is something not to be accepted. The other point is on resilience. We keep telling women, in women empowerment programs, women should be empowered and they should fight back. But most women are not in a position of power. They are not resilient enough to fight, so to speak. So the change must come in a much deeper way, by dismantling a lot of these institutions of patriarchy. They start with our schools, of course, and they start with our families, and it can be like small 2 minute or 30-second bites on TV, saying that, do you beat your wife, then you're a criminal, you know that kind of a thing. That kind of a messaging, I think, is very important, because you can't wave a magic wand and expect patriarchy to go. And at the same time, it's not right to place the burden upon the of patriarchy on women, saying that, oh, you don't like patriarchy, you fight against it. Patriarchy is not something which is a men versus women's issue. It is an abuse of power issue that all of us, being aware of the fact that power corrupts and absolute power corrupts absolutely, must be very sensitive to, whether it is in the context of gender, whether it is in the context of disability or caste. These are things that all of us should be involved in the fight. It's definitely, I do not see it as a men versus women's issue. Thank you.
Thank you so much, ma'am. Isha ma'am and Tamanna ma'am, we would love to hear if you have to add anything as in addition to what Thomas ma'am just said, starting with Isha ma'am. You have not. Ma'am, you're on mute. You may please unmute yourself. We can't hear you, ma'am. You may please check in with the technical issue, and meanwhile, we'll move to Dr. Tamanna. Ma'am, do you
Yeah,
have to add anything to what Thomas ma'am said?
I think she's completely mentioned everything. But I wanted to quote Rosie Braidotti, one of the prominent French feminists. And she said that the primary goal of feminism is thus not to deny differences, but to recover the feminine within the sexual difference, to generate an autonomous female imaginary beyond the existing stereotype of women. So I guess differences do exist. We need to accept it, but we need to have a general platter where men and women interact as human beings, not as enemies. And till that time happens, then differences are acknowledged and respected. I guess that respect and empathy is must for men, and that has to be taught in homes. And if women have women related education, and men are also taught feminism, for example, now we do teach, and many of the students, for example, the ones we teach are extremely sensitive, which is very heartening to most of the teachers when we teach them, and they ask so many questions and they are so keen. So till the time, that education should be starting from the KG level, so that slowly and gradually parents are also sensitized and the students are also sensitized.
You may please check in again, ma'am. We're so sorry, we still can't hear you. And as we've moved towards the end of the session, so I would like to conclude the session with an observation which the Apex Court have made. in the landmark right to privacy case, and also back in 2018, the Joseph Shine's judgment, that validity of a law has to be tested not with reference to the object of state action, but on the basis of its effect on the guarantees of freedom. And if the consequence is so that it undermines the married woman's right and she could be subjected to sexual assault, then it should be viewed as nothing but an instrument of oppression. We thus conclude by saying that sexual autonomy is a core part of right to dignity of every individual, and a legal provision which curtails the autonomy for a married woman is antithetical to the constitutional values. It was my privilege and honor to have hosted such a wonderful panel. Your insights are extremely valuable to us. Looking forward to many more enriching discussions. Thank you so much. I request Nandini to please take over. Thank you.
Thank you, everyone. It was an absolute delight listening to you all. Genuinely, especially personally as a law student also. I would now like to invite our faculty coordinator, Ms. Neha Tripathi, to deliver the vote of thanks. Ms. Tripathi is currently working as an assistant professor of law at Maharashtra Law University, Aurangabad. She is also a PhD scholar at National Law University of Delhi and has more than 4 years of teaching experience. She has specialization in constitutional law and human rights law and currently teaches administrative law, comparative constitutional law, and interpretation of statutes to undergraduate and postgraduate students at the university. I would also like to express our sincerest gratitude to ma'am for giving us this opportunity to conduct the panel discussion and for being a constant guiding force. Thank you.
Thank you, Nandini. Thank you, Aishwarya. Good afternoon, everyone. Respected Professor Sarasu Thomas, Dr. Tamanna Husla, Ms. Isha Singh, our most valued invited guests, ladies and gentlemen. It's a privilege to propose a vote of thanks on this occasion. On behalf of MNLUA fraternity, I take this opportunity to propose vote of thanks to those who have directly and indirectly contributed to the conduction of this panel discussion on marital rape, a legal dilemma, organized by our university. At the very outset, I would like to extend my heartfelt gratitude to the dignitaries for accepting our invitation and addressing the gathering today. We are really enlightened with your knowledge and presence. We are thankful to our Vice Chancellor, Professor KVS Sharma, and Registrar Dr. Ashok Vajje for their support and motivation. I would like to recognize and express our regards to the teaching and the non-teaching staff of the university for their constant support and upliftment which we have received from them. A special thanks to the organizing committee and student team members of Center for Research in International and Comparative Laws, Maharashtra National Law University, Aurangabad. They need a huge round of applause for their unflinching support and coordination, some of whom are worth mentioning here due to their enthusiastic and untiring efforts for making this panel discussion a success. Sulabh Gupta, Aishwarya Pandey, Nandini Tyagi, Parag Kabra, Shivek Jhanda, Riya Garg, Rupsi Narlikar, and others who have worked really hard behind the stage. So last but not the least, we also would like to extend our gratitude to Mr. Sushil for his technical support. We look forward to host you for upcoming event by Center for Research in International and Comparative Laws, MNLU Aurangabad. With these warm words and a kind message, we move to the end of today's panel discussion. Thank you so much, ma'am.